The investigation into former President Trump's handling of classified documents. Sources telling ABC News that a federal judge has ruled Trump's attorney must give more testimony to a grand jury. ABC's Jay O'Brien is in Washington with the latest. Jay, good morning to you.
Whit, good morning to you. All of these proceedings are secret. They're kept away from public view because they're part of an ongoing federal grand jury investigation. But sources telling ABC News that Evan Corcoran, who's an attorney for former President Trump, has been ordered by a federal judge to give additional testimony to that grand jury, which is investigating classified documents seized by the FBI at Trump's Mar-a-Lago estate. Sources familiar with the matter say that special counsel Jack Smith wants to question Corcoran about the former president's potential efforts to obstruct federal officials from getting those classified documents back. In particular, sources say investigators are zeroing in on a call between Trump and his lawyer that allegedly took place on the day federal investigators subpoenaed surveillance video from inside Mar-a-Lago, suspecting Trump was still holding on to classified materials.
Hey crew, it's Adam here. Picture this: a federal courtroom, 12 jurors seated. The prosecutor rises and calls their next witness. The door opens and in walks the defendant's own lawyer, not some hostile witness from the outside, not someone with an axe to grind or a book deal to chase. His own attorney, the person he trusted with his most sensitive secrets.
Donald Trump's attorney, Evan Corcoran, arrived at a Washington, D.C. courthouse. You can see him there to testify to a grand jury without the protection of attorney-client privilege. Corcoran must also hand over documents and notes related to his legal work with the former president. This is all about the Mar-a-Lago classified documents investigation. CNN's Caitlin Polantz live outside the courthouse in Washington, D.C. Evan Corcoran is inside. Caitlin, so what's happening?
Indeed, Evan Corcoran is inside the courthouse, and we do believe he's back with the grand jury at this point, a little bit after 9. His attorney is here as well, so it is quite clear that he isn't complying with this court order, that he provide answers he did not want to give, and that his client, Donald Trump, did not want him to give to the grand jury about their communications as the federal government was trying to get back classified records at Mar-a-Lago.
The person covered by an ancient legal protection called attorney-client privilege that's supposed to guarantee that whatever you tell your lawyer stays between you and your lawyer forever. That privilege? Gone, stripped away by a federal judge. And now that lawyer is on the stand, under oath with detailed handwritten notes, testifying about what his client asked him to do. That is not a hypothetical scenario. That is not something from a legal thriller.
We learned last night from my colleague Sarah Murray and a source she was speaking with that what they want to ask him about is that response after May of last year, where the federal government sent a subpoena demanding all classified records be returned to them. And there clearly were conversations between Corcoran and Donald Trump then, including in June. That is what we know they want to ask him about, and that he is going to have to respond to today inside the grand jury. He did just go in a few minutes ago, and typically these types of appearances can last for hours. So we are going to be waiting. It is entirely confidential what happens inside that grand jury room. So we won't be able to see it like we do other court hearings. But this is really a critical day for the special counsel's investigation, and also a really unusual day to have a lawyer for Donald Trump being forced to come back to court and testify again. John?
That is the exact situation Donald Trump is sitting in right now. And how we got here is genuinely one of the most unbelievable self-inflicted legal wounds any president has ever managed to create for himself. Most people scanned a headline and kept scrolling. Most people have no idea how deep this actually goes. But when you lay out the full picture, every single layer makes it worse. Here is what actually happened. Donald Trump's own attorney, Evan Corcoran, kept detailed notes of conversations where Trump allegedly pushed him to lie to federal investigators, hide classified documents marked as national defense information, or destroy sensitive materials rather than turn them over after receiving a lawful federal subpoena. Corcoran said no. He documented every single request in real time. And then a federal judge dropped the hammer using something called the crime-fraud exception, an extraordinarily rare legal ruling that completely obliterated attorney-client privilege and forced Corcoran to testify before a grand jury about exactly what Trump allegedly asked him to do. Think about that for a second. The privilege that exists specifically to protect conversations between a client and their lawyer completely wiped away. Stripped by a federal judge who reviewed evidence and found probable cause that Trump allegedly tried to use his own attorney as an instrument of a crime. And now those conversations, the ones Trump believed were forever shielded, are part of the permanent federal court record with absolutely no way to walk them back. And here is what makes this even more outrageous. When Corcoran refused to go along with what Trump allegedly wanted and told Trump he was going to conduct a thorough search of the storage room at Mar-a-Lago to locate every single classified document, Trump allegedly had his personal aide, Walt Nauta, move boxes out of that room before the search could happen. Boxes full of classified materials. Moved so the lawyer would not see everything. So the lawyer could certify to the Justice Department that a complete search had been done when it actually had not. Do you understand the sequence here? Trump allegedly asks his lawyer to lie. The lawyer refuses and documents the request. Trump allegedly has boxes moved behind the lawyer's back to make the lie unnecessary. The lawyer documents that too. And then a federal judge forces the lawyer to testify about all of it. At every single turn, Trump's own alleged actions created more evidence against himself, not less. His own lawyer's notes are now the prosecution's roadmap. His own aide is named in the obstruction timeline, and a federal judge has vaporized the privilege that should have protected every single one of those conversations. Here is what makes this story so politically and legally devastating right now. Trump keeps telling the public he did nothing wrong in the documents case. He keeps insisting he cooperated fully. He keeps framing the entire prosecution as political persecution. But in court, where the actual evidentiary record is being built, his silence is being filled by his own lawyer's words, forced into the open by a federal judge, backed by detailed notes that contradict every single public claim Trump has made about how he handled classified documents. He does not even have to speak for the damage to be done. His own lawyer is doing it for him, under oath, with documentation, after a judge ruled that the normal legal protections do not apply because the conversations themselves allegedly involved criminal activity. That is the story. That is the trap. And Trump allegedly built it with his own hands. Let's break this down piece by piece because the Corcoran testimony story has several layers that each need full attention before the complete accountability picture comes into focus. The crime-fraud exception and why a judge invoking it is such a seismic legal event. What Corcoran's notes specifically allege Trump asked him to do and why those requests constitute alleged criminal conduct. What the box-moving episode adds to the obstruction picture. And what the pattern of Trump's inner circle becoming witnesses means for the broader legal trajectory. Each of these layers is significant on its own. But when you stack them together, you get something that is genuinely impossible to dismiss as politics or noise. Start with the crime-fraud exception, because that ruling is the foundation everything else rests on. Without that ruling, none of this could have happened. Attorney-client privilege is one of the most sacred protections in American law. It exists for a crucial reason. Defendants must be able to speak completely honestly with their lawyers without fear that those conversations will be weaponized against them. The entire adversarial system depends on lawyers receiving full candid information from their clients. A judge stripping that privilege is not routine. It is not common. It is an extraordinary legal step that only happens under one specific condition. When a judge reviews evidence and finds that the attorney-client relationship was being used not for legitimate legal representation but to facilitate or plan a crime. That is the crime-fraud exception, and a federal judge applied it here. Which means a federal judge looked at evidence and found sufficient basis to conclude that Trump's conversations with Corcoran were not protected legal discussions. They were allegedly attempts to enlist an attorney in criminal conduct. That is not a procedural technicality. That is a federal judge making a substantive legal finding that has enormous implications for every subsequent phase of the case. When a judge strips privilege, it means the judge has already seen enough to believe the conversations were criminal in nature. That determination is in the record. It is permanent. And it is the specific legal foundation everything Corcoran subsequently testified about is built on. The specific requests Corcoran allegedly documented need to be laid out clearly because each one represents a distinct alleged criminal act. According to court filings and the sealed notes, Trump allegedly pushed Corcoran to tell the FBI that Trump no longer had any classified documents when Trump allegedly knew that was false. That is suborning perjury. Trump allegedly suggested the attorney could hide sensitive materials rather than turning them over after a subpoena. That is obstruction of justice. Trump allegedly explored whether documents could be destroyed rather than produced. That is destruction of evidence subject to a federal legal hold. These are not minor asks. They are not ambiguous conversations that could be interpreted multiple ways. They are, if Corcoran's documented account is accurate, a client allegedly asking his lawyer to commit multiple distinct federal crimes on his behalf. And Corcoran said no and wrote it all down. You do not instruct your lawyer to lie to the FBI, hide evidence, and destroy documents and then expect that to stay quiet forever, especially when the lawyer says no and takes notes. Detailed contemporaneous notes that a federal judge later forced him to share under oath with a grand jury. The detail about Trump privately expressing fear in 2022 that handing over the classified documents would get him in trouble is the specific piece of the Corcoran notes that most directly guts Trump's public cooperation narrative. Because if Trump was genuinely innocent, if he genuinely believed he had done nothing wrong with the documents, the conversation with his lawyer would have been very simple. Here is everything. Let's hand it all over. I have nothing to hide. That is what innocent people say to their lawyers when they receive a federal subpoena. What Trump allegedly said instead, according to Corcoran's documented account, was an expression of fear about what producing the documents would mean for him legally. That fear, allegedly documented by his own attorney, is the specific evidence that most directly contradicts every public statement Trump has made about his confidence in his innocence. He allegedly told his lawyer he was scared of what handing them over would reveal, and his lawyer wrote that down in real time. And a federal judge later decided that note was not protected, and a grand jury heard it. And now it is part of the permanent federal court record that cannot be taken back. That specific detail, a president allegedly expressing fear to his own attorney about what producing evidence would reveal, is the single clearest documented window into alleged consciousness of guilt in this entire case, and it came from his own lawyer's notes. Now, let's talk about the box-moving episode because this is the dimension that takes it from a dispute between a client and a lawyer and turns it into a documented pattern of alleged obstruction with a second-named participant. Walt Nauta is Trump's personal aide. According to prosecutors, after Corcoran refused to help conceal the documents and told Trump he was going to conduct a proper search of the storage room at Mar-a-Lago, Nauta allegedly moved boxes of documents out of that room before the search happened. So when Corcoran conducted his search, he did not see everything. He produced a certification to the Justice Department that was allegedly knowingly incomplete because Trump allegedly had evidence moved to make it appear complete. The lawyer refused to lie, so allegedly the boxes got moved to make the lie unnecessary. That is the alleged sequence. And Corcoran's testimony and notes combined with the evidence about the box movement create a documented timeline of alleged obstruction that prosecutors have been building their case around ever since. This is not a gray area. This is not a disputed interpretation of ambiguous language. This is an alleged physical act of obstruction. Boxes moved, evidence hidden, a search allegedly manipulated to produce an incomplete result that directly corroborates the documented expressed intent captured in Corcoran's notes. The words in the notes and the movement of the boxes point in exactly the same direction, and that alignment is what makes this episode so significant. The broader pattern dimension is the context that makes this story most significant for the overall accountability picture. This is not the first time a Trump world lawyer has become a witness against him. Michael Cohen went from personal fixer to federal witness. John Eastman had his phone seized by federal agents. Rudy Giuliani faced his own legal exposure over conduct tied to Trump's political operation. And now Evan Corcoran, the attorney Trump hired specifically to handle the classified document situation, has been forced by a federal judge to testify about what Trump allegedly asked him to do. The pattern of Trump's own inner circle producing the most damaging evidence against him is not a coincidence. It is the documented consequence of a client who allegedly keeps asking the people closest to him to participate in conduct that those people then document, refuse, and eventually testify about. The inner circle keeps becoming the witness list. And the witness list keeps growing with each new case and each new set of allegedly documented requests that the people around Trump were not willing to go along with. Think about that for a second. The people he trusted most, the lawyers, the aides, the fixers, keep ending up on the other side of the courtroom. Not because prosecutors found them, but because they allegedly kept being asked to do things they would not do and then documented it. Jack Smith's obstruction theory is built directly around this documented sequence. Smith is not just arguing that Trump wrongfully possessed classified documents. He is arguing that Trump repeatedly and deliberately attempted to obstruct the lawful recovery of those documents, first by allegedly asking his lawyer to lie, then by allegedly having boxes moved before the lawyer could see them, then by allegedly having security footage deleted, then by allegedly coaching other witnesses on what to say. Each of those alleged acts is a separate count in the obstruction architecture Smith has been building, and Corcoran's testimony and notes sit at the foundation of that architecture, providing the specific documented evidence of alleged intent and deliberate obstruction that prosecutors need to move from a documents case to a full criminal obstruction case. When your own lawyer's notes are the prosecution's primary evidence of your intent, you have a serious legal problem that no public messaging campaign can fix. Here is where we land. The crime fraud exception ruling, the specific requests Corcoran allegedly documented, the box-moving episode, the judicial finding of criminal endeavor, and the broader pattern of Trump's inner circle becoming witnesses, all of it together creates the most complete obstruction accountability picture the Mar-a-Lago documents case has produced. And each of these pieces reinforces the others. They are not separate stories. They are one documented sequence. A sequence where a federal judge has already found sufficient basis to strip attorney-client privilege, where the president's own attorney has already testified under oath to a grand jury, where the documented notes of that attorney already sit in the federal court record, and where the prosecution's obstruction architecture is already built around the specific alleged conduct that Trump's own lawyer documented in real time. The trap was not set by Jack Smith. The trap was allegedly set by Trump himself. Every time he allegedly pushed someone close to him to participate in something they refused to do and then documented, another witness was created, another note was written. Another piece of the obstruction architecture was handed to prosecutors by the people Trump allegedly tried to use. That cycle is not over. And the next development in this case is going to make today's story look like the beginning of something much bigger. The documented record of what allegedly happened inside Mar-a-Lago when a president allegedly tried to make his own lawyer part of the solution, and the lawyer said no and wrote everything down, is permanently in the federal court record. It is the foundation. It is what this case is built on, and every new development that comes out of this case is going to be measured against that foundation. Stay tuned.